Okay, so welcome to our panel, Heirs, Property, and Access to Justice, Changing the Conversation. My name is Annie Eisenberg. It's really nice to be back here at WVU. I just left a couple years ago after doing a 2-year fellowship as a clinician in the Land Use and Sustainable Development Law Clinic. So it's great to be back. I now teach a transactional environmental law clinic at the University of South Carolina, which was initially inspired by the land use clinic here. And so we deal with complex property questions a lot of the time. Before we get rolling, I do want to just thank, on behalf of myself and the panel, Rebecca and the rest of the Law Review team. This has been such an amazing event. We're so glad to be participating and closing it out. Thank you for being here and sticking it out until the end. So I'm really glad to be moderating this discussion about heirs property today. I'm pretty new to the heirs property world, which actually puts me in a good position, I think, to kick us off with a few minutes of laying the foundation. What is heirs property? I'm going to do heirs property 101. What is this issue? What are the concerns surrounding it? So I'll do that just for a couple minutes. I'll introduce our great panel after that. Obviously, we have two folks speaking with us remotely, so I had in here to bear with us if there are technical complications, which you have already done, and we're up and running now. Then we'll hear from the panelists, each of whom is offering a different perspective on the question of heirs property and access to justice, and I hope at the end we will be able to have a little bit of conversation and participation from everybody here. So, what is heirs property? I am going to ask Jesse, aka Professor Richardson, to chime in. He taught me everything I know about heirs property, so as I proceed to get everything wrong, we can blame him, but we can also consult with him about kind of this heirs property 101 framing. So let's start with just how does inheritance of land tend to work? Usually there are two ways that it goes. Let's say I have a parcel of land, I write my will, I pass it on to my 2 kids. That's nice and clear, right? We know who gets what. We have clarity for my family. We have clarity for our community and for the rest of society. We have legal documents that establish, here's who owns what. So you can do that through a will. If I don't have a will, you go through the intestacy process, also known as probate. I don't know if those are...
Not exactly.
Not exactly. Okay, well, we're going to gloss over that and say something happens. I don't have a will. There is a process for dividing up and distributing my estate. There are state laws that have a pre-existing set of calculations. And the hope is that once you go through that process, you'll get a similar result for my property. It will be clear who owns what. It will be manageable both for purposes of my family's kind of functioning and relationship with this property, but also vis-a-vis the community. There's some kind of clarity as to this land. And so these processes get repeated from generation to generation, and the hope is that you have a nice, clean, just transition of property titles and get that managed in a way that's good for the family and for the community. So how heirs property comes to be why we call it heirs property is that you see a property that's passed through a few generations, potentially without explicit engagement with those formal processes, or there has been engagement with those formal processes, but and how would you characterize it if it has gone through probate, but what has gone wrong if you've gone through probate, but you still end up with a piece of heirs property?
It's still, basically, they just leave it to their kids equally, and leave it to their kids equally, and leave it to their kids equally.
Okay.
And it becomes highly fractionated.
Right, okay. So the effect, ultimately, is that you have a parcel that has been fractured is a good word. You have, let's say I have 2 kids. They each have 2 kids. The next generation each has 4 kids. all of those heirs could end up with an interest in my 2 acres. And so that pretty clearly is not all that manageable. You end up with, let's say, 32 individuals with interests in a property. They could be scattered all over the country. Some of them might not even know that that property exists. Maybe 1 or 2 of them live on the property. Others don't know it exists. You have sort of infinite permutations of how multiple heirs, potentially a very high quantity of heirs, might relate to the piece of heirs property. And as you can imagine, if you're living off in another, sorry, I'm just gonna adjust this. If you're living off in another state and you don't live on the property, your relationship with the property is very different than if it's your main residence. And so all of these complications sort of factor into how families relate to the property and how it might be dealt with. So why heirs property is problematic? There are a few ways in which this fractured multiple owner interest model ends up being troublesome. So the first concern there is the wealth concern. So first off, you might have, and I don't know if you coined these terms, but I learned them.
Brady Deaton did.
Brady Deaton,
My
okay.
friend Brady.
Brady Deaton's terms, there's the wealth concern and there's the vulnerability concern. So the wealth concern is that, especially for a poor family, this land is an asset. This is a major source of wealth. It might be one of few assets for the family, but this cloudy title and unclear ownership and the fractured ownership really impedes the full utilization of this property as an asset and as wealth. One way in which that works is that if you have a property with such a thorny title, you can't get a loan on it. You can't make improvements. The property can fall into disrepair, and you really can't sell it. So it's wealth and it's an asset, but it's sort of frozen and underutilizable. The vulnerability concern is kind of in a separate vein. Let's say cousin Joey from Philadelphia, he's never visited the property, he doesn't know it exists, he's one of 32 heirs, and a company goes to Joey and asks to buy his interest in the property. And Joey, for whatever reason he decides to sell, that opens up the property and the family to vulnerability of loss of the asset, because now you have this outsider with an interest in the property and the potential to seek a remedy like a partition suit. So it renders the property vulnerable for being taken out of the hands of the family, which goes back to the wealth concern because it can be family's major asset. There's also sort of a bigger picture concern about the community problem of heirs property. So when it's hard to leverage your equity in heirs property and get loans and make repairs, and because there can be this lack of clarity who is responsible for this property, there's a strong correlation between heirs property and dilapidation, properties that fall into disrepair and don't get maintained. Dilapidation is also strongly correlated with abandonment, which can then contribute to a community's larger socioeconomic decline as houses fall further and further into disrepair or abandonment. So it's not just a concern for the individual families who are struggling with this, it can be a concern for the community as a whole. Taking a step back and looking at, so now we've done Heirs Property 101, I've hopefully not misinformed you in too major a way. The conversation on heirs property is also a part of heirs property. So the conversation on heirs property tends to take sort of a negative tone. It emphasizes the thorniness of the problem and the complexity of the problem, the problematic parts of the problem. So heirs property is disproportionately burdensome on certain communities. Native American communities, African American communities, and Appalachian communities. And the narrative tends to go along the lines of, oh wow, these populations, they can't get a lawyer, there aren't any lawyers around them, people can't afford an attorney, there's minimal engagement with the formal legal system, and now these properties are really messy, how could we ever possibly untangle them? And the goal of this panel is to switch tones from that common theme and to be much more solutions focused and to try to challenge that narrative. And that really fits with one of the themes I've been hearing at this symposium about the problem of storytelling by people who aren't living the story, which I think is very much a part of the Appalachian story. And I had a conversation with an attorney at the Center for Community Progress who is at least closer to the story than I have been. We talked about the conversation on Ayers property, and she had a couple of thoughts about how the Ayers property story really can be viewed differently from what we commonly hear. So she made 2 points about framing that really stuck with me and I think will be helpful for launching the rest of our panel's conversation. So the first point that she made was, think about, at least consider, what if this wasn't an accident? What if this highly fractured ownership was either an intentional or subconscious effort to come to that result? And the reason that might be is that the communities that have a large proportion of Ayers property, including Native American, African American, Appalachian communities, are also communities where outsiders have been trying to get people's property for a long time and oftentimes succeeding at that. So there could be, again, whether intentional or unconscious, a move to protect the property in a way by making it less desirable to outsiders and by making it more difficult to get at it, at least in one way, by encumbering the title, protecting the property in a spider web of real estate and property questions. So the Ayers property as protective shield idea conflicts with the standard narrative and centers Ayers property in a potential idea of community autonomy and a rational strategy, rather than a community that just hasn't been engaging with the justice system. And the second point that this colleague made was about this latter point. We tend to characterize this issue as a negative in another way, that it's this community failure to engage with the justice system somehow. But we could also recognize for many communities that there has been something positive and affirmative that they have been engaging with instead of the formal justice system. Say oral traditions of passing property down, for example, or other informal mechanisms for resolving questions about property that have deep meaning for those communities, or a value system or set of experiences that just haven't included these formal processes that we tend to focus on. And again, we can reframe the discussion from suggesting that there's some vacuum here or an emptiness or an absence of the justice system, but instead focus on the presence of other norms that have taken the place of where the justice system tends to be for those of us who are part of different communities. So I hope that sets the stage somewhat now for what we'll be hearing from the rest of our panelists, who I'll quickly introduce. Speaking up next, remotely, we have Mavis Gregg, who, among many other accomplishments, is a North Carolina-based attorney in private practice. She is driven by her passion to help individuals and families grow their wealth. She does this by assisting her clients with estate planning, estate administration, and heirs property matters specifically. We also have John Schelhas joining us remotely. He is a research forester with the Southern Research Station of the U.S. Department of Agriculture Forest Service. His research centers on relationships between people and forests, and he has specifically conducted community-based research on heirs property retention in the South. Jesse Richardson is a professor here at WVU and the lead land use attorney for the Land Use and Sustainable Development Law Clinic. He regularly publishes research on the law and policy questions surrounding heirs property. So with that, we'll get started and hear from Mavis.
Thank you, Annie. Good afternoon, everyone. Hopefully you can hear me okay?
Yes.
Great. So as Annie mentioned, I practice law in North Carolina. I have a law practice based in Durham, which is in the center of the state, but I have a footprint across the state of North Carolina because a lot of my clients are heirs property owners, particularly in northeastern North Carolina, but I have some in the area where I live and also in western North Carolina, which is where I'm from. So I'm actually an Appalachian native. So it's exciting to be a part of a symposium that focuses on a place I consider home. So in my practice, I focus all on death and dirt. So estate planning, estate administration, heirs property, and I did that because I felt like folks that are most vulnerable with respect to our laws and how our economy is functioning are those who are land rich, cash poor. And so I try with my practice to help people preserve their land as a source of intergenerational wealth. And that is particularly needed with heirs property owners, as you've already heard. I thought I would talk about working with heirs property from a practical standpoint, since I'm working with clients, and then hopefully we can hear from the academics about their thoughts about how we can change the conversation around heirs property and also make deeper impacts with heirs property. In my practice, most of my clients who are heirs property owners have been connected to me through an existing program. I'm going to speak about the Sustainable Forestry and African American Land Retention Program. And one of the sites for that program in North Carolina is with Roanoke Electric Co-op Development, Inc. So there's an electric co-op in northeastern North Carolina that serves 6 counties, and they have a nonprofit that participates in this program. And as a part of this program, the participants learn about how to keep their land. So they learn about estate planning, they learn about heirs property, and then they also get reimbursement for legal fees pertaining to keeping their land legally secure. So legal fees to do the estate planning, to put their property into a trust or LLC. And I'll talk a little bit more about why we want to consider that. And then also to unravel any type of title issues when we're dealing with heirs property. So if any of the participants are heirs property owners, they can get legal assistance reimbursement for that. And then the clients come to me. So at the outset, with heirs property, I'll have one family member or a couple of family members who come to me and say that we have this family land, we want to use the land, or we're not able to use the land as optimally because we can't qualify for a loan, or we can't get these grants because we need to be able to prove ownership. And so then we talk about the history of the ownership of the family property, which really is talking about the family tree. And the family tree is so essential when we think about chain of ownership. As Anne alluded to, a lot of the land has been transferred from owner to owner by virtue of death. So we know that you can transfer ownership of real estate with a deed, which is a legal document that's recorded in the Register of Deeds, which is called in North Carolina, or it could be the Recorder's Office. But if land ownership is transferring at death, then the records that we refer to would be the estate administration records. For most people, most Americans do not have estate plans, and that includes a will. And for many Americans, many Americans, when someone passes away, they don't do the estate administration process, which is the legal process for settling one's affairs. So doing that would actually create a legal record of who the heirs of that person are. And so in doing a title search, we can look for the last deed related to the property, and then look at the estate administration records and a mixture of the family tree and other records to determine how the family's property has transferred. But oftentimes, we don't even have those records to rely on. Oftentimes, the only records we have to rely on are the deed into the matriarch or patriarch or both that is in the early 1900s. And then we're looking at the family tree, which we know family trees aren't official legal records. And then depending on the circumstances, meaning depending on when our original owners passed away, and then the next generation of owners, when they pass away, we conduct a title search, and then we may have to fill in the blanks by administering some estates for people who passed away a long time ago. So for example, I have a family where the original owners purchased the property in the 1930s, a couple. They purchased the property in the 1930s. They actually anticipated the legal issues that could happen by not having an estate plan. So they transferred the property in 1980 to their children. They had 10 children. So they deeded the property to their 10 children in 1980. And then in 1998, the first child passed away. And then the next 2 children passed away in 2006, 2005. And then we're left with the 7 original children, and then some heirs. So we went from 2 owners to 10 owners to now 16 owners. And I actually had to administer the estate for 2 of the people who passed away a long time ago. And the reason why is so we could create a clear record of who became owners of that property. And so that's a common example where we're dealing with people who died a long time ago and addressing the estate administration process much later, just so that we can create a legal record. And it takes a lot of time, it takes a lot of patience. Obviously, when you have multiple people who own property, they may not have the same ideas about how we should address resolving the legal issues. And it's also very precarious. As Annie mentioned, one of the resolutions for owners is that they can transfer their share to someone else. So when property is transferred by virtue of death to multiple owners, they become owners as tenants in common. Now, I'm going to speak from a perspective of North Carolina law, but I think it's applicable in other states as well. When you have property as tenants in common, any owner can transfer their share. To transfer the whole, it requires all of the owners, or to burden the property with a mortgage or a deed of trust, it requires all of the people to sign off on it. But any one of the single tenants can transfer their share to whomever they want. And any one of the owners can also petition the court to divide the property. And in North Carolina, if the property cannot be divided equitably, not equally, but equitably, then the property is then sold in lieu of partition. So doing either of those takes the decision-making from all of the owners and puts it into a third party who often doesn't know the land. Most clerks of courts are not, they don't have the same appreciation for a family's land and the history of the family's land and what the land has meant for them. And they have the power to make a decision on what happens to the family's land. So it's in my view, a very demoralizing process when heirs are looking to the courts to decide what happens with the family's land, especially when we're talking about land that's been in a family for close to 100 years and has been a significant economic resource for the family, a significant source of home for a family and identity for a family and legacy for a family. It gets stripped away. So with that in mind, I'll also add that many attorneys, when they're approached by heirs property owners, their first thought is to petition the court to divide the land. That, oh, you have a bunch of owners of this land, let's split it up. That's the easiest thing to do, is split the property up. And I'm sure John will vouch for me when saying when you divide land up, the economic value of it diminishes significantly. If you have 100 acres that can be used as a forest, you can make so much more money than if you have 10 acres. Or if you're doing farming, or if you're living on the land, there's so many benefits of keeping the land intact from an economic perspective. But that's what most lawyers go to. Unfortunately, we like, I don't know if the audience is made up of lawyers, but unfortunately, and ironically, we're often conflict averse, and we try to choose the easiest route to a resolution, but it's not always the best route. And then again, like I said, in North Carolina, if it can be divided, then it's sold, just like foreclosure. So I think that something that we can do as practitioners, well, one, we should embrace our ability as legal professionals and other service providers in helping landowners come up with creative approaches to protecting their land. And that includes involving other professionals such as mediators and arbitrators in the process of negotiating what's going to happen with the family land. We may have mediation training, but actually hiring people who are skilled at working with families and family dynamics to help the families address the issues and concerns of each owner and coming up with a solution that works best for them. But stepping back a little bit, I think also from a practical standpoint, it's important for us as practitioners and for the client, for the actual owners, to approach the heirs property in steps, addressing the legal issues with heirs property in steps. So with my clients, I actually engage them with a limited scope engagement, and I require that before we start working together, that they have a pretty robust family tree that goes back to their original owners. So start first with the family tree and talking about that family tree and making sure that it includes everybody. I have lots of funny stories about people who assume someone's a family member or someone's not a family member by virtue of their relationship and the dynamics in the family. I've had plenty of people omitted from the family tree, so I often have to counsel people on, how to include outside children and spouses, because spouses in North Carolina and other states as well inherit through intestate succession. But work on the family tree first, and then they can hire me for a limited scope engagement just to do a title search. And the reason why I do that is because I want to make sure that they appreciate the extent of the work that we have to do, and that we may not be able to get conclusive information about the chain of ownership. Recently, I was working on a title search for a family that the patriarch purchased the property in 1915, which is a long time ago, over 100 years ago. And he had a lot of kids, and each of his kids had a lot of kids. So just in going through the family tree, I was able to identify at least 71 owners, present owners. And that's a lot of people. So by the end of the engagement, because he only hired me for that one to find out who the owners are, I was able to counsel him and say, you have 71 owners and 45 acres. Do you want to go further? Is it helpful for you from an economic standpoint to pursue this further? Because if we do that, then there are these many people that we need to involve. Now, once we finish, if a client does want to go beyond the second step, which is the title search, then the next step is engaging the owners in a conversation about what they want to do with the property and what that looks like. A lot of times people become owners, well, almost in all cases, people become owners and they don't know anything about the property. They don't know, they've not even touched the property. They have a lot of people move to urban areas. They even move out of the state, and they don't know about the old home place. And so they become owners involuntarily, and they gain wealth, but they also gain a lot of legal responsibility. And so getting those folks to talk about what they want to do and engaging them in a process that empowers the owners to make informed decisions is a crucial third step. And it may, again, end with not going further. But then if we do go further, the next step and the ideal with heirs property is to transfer the ownership into a single entity owner, such as a trust or LLC. And that really depends on the circumstances and how the families are going to use the property. But putting it in a single entity owner allows the owners to have a management structure that works for them. So they can have people who are specifically in charge for the day-to-day activities of the property, and then they can have people who just benefit from the property and don't have to be engaged and don't have the authority to make decisions on the property. With heirs property as tenants in common, you need a unanimous vote. But if you can put it in a single entity, then you can create the voting structure. It could be a majority vote. It could be that the manager of the LLC makes all the decisions for the day-to-day operations. it gives them a lot more flexibility and a lot more power with how their land is used and operated. How am I on time, Annie?
We've got about 5 more minutes. Can you hear
Okay.
me? Yeah, okay.
Yeah. 5 more minutes. So yeah, those 4 steps I think are crucial. I think as practitioners, it's important for us to be very deliberate and counsel the parties on doing that. And then just bigger picture, I think all of us, whether we're lawyers or foresters or academics, I think it's important for us to be connectors for heirs property owners, connect them to the different resources. The program by the U.S. Endowment is phenomenal. I think it has uplifted so many owners across the Southeast by giving them knowledge about forests. I mean, I didn't imagine when I started my law practice that I would learn about trees. But forestry is a big industry. In North Carolina, forestry is a $23 billion a year industry. It's money. It's also, you know, important to think about forestry from an environmental standpoint. But the programs like this, connecting landowners to these types of resources like John, are so essential. And we can serve as connectors, connecting people to these. We can also host workshops. I think it's great that you all have a symposium that's educating the practitioners and the lawyers, but we can also go back to our communities and host workshops, bring people in to talk about forestry, to talk about estate planning and heirs property. And then I think we should also be a resource by funding opportunities for heirs property. It is expensive, but I think that there are a lot of resources available that could help the landowners do their family tree. That doesn't require an attorney. You can hire a genealogist or give them a subscription to Ancestry.com or connect them. A lot of people don't know that the Church of the Latter-day Saints, the Mormon Church basically, has family history centers all across the country that are available for free, where you can go and research your family genealogy and create that family tree that's essential to the title search process for heirs property. And then just thinking about, just a side note, the points that your colleague made, Ann, about how heirs property became what it is. I would respectfully disagree with both her points. I do think family land ownership is a cultural value. I think lots of cultures embrace the idea of having intergenerational land, wealth, and for many, in just thinking about America alone, intergenerational wealth connected to your land is a common practice. I think many people, particularly people of color, literally did not have access to legal resources to do the type of planning that was aligned with our Western legal system. And you see that in other countries as well, such as Ghana. Ghana just introduced a land registration system in the 90s, I believe, or late 1980s. And it's wreaked havoc on family-owned land because these families are transferring land from generation to generation because they had a right to, from a legal perspective, and it was a cultural value. And then this Western system of land registration was implemented and disrupted that completely and caused a significant amount of land loss. I do think those are interesting theories, but I don't agree with them. And I'd love to hear more from you all about what you think about that.
Thank you so much, Mavis. Great, okay, now we'll hear from John.
Okay, I'm going to see if I can get my screen on there.
I am making you a presenter.
Oh, good.
Nice to be able to
Show
show
my
you.
screen. Okay, now I'm going to get rid of some stuff so I can see my screen. Okay, and I'm going to maximize, whoops. So can you see my screen now?
Yes.
Is a picture of me blocking it?
No. Nope. No.
Great. Okay. Okay. I'm going to proceed. So I'm John Schelhas. I am with the Southern Research Station of the Forest Service, U.S. Forest Service. I'm in Athens, Georgia. I was stationed at Tuskegee University for 11 years. I've been in Athens for about 8 years, and I've been working with African American forest owners then for almost 20 years. And my colleague, Sarah Hitchner, has been working with me since I came to Georgia on a number of different projects. And so I'm a forester and an anthropologist, and Sarah is an anthropologist with an interest in forestry. So I wanted just to say a few things about Ayers property. Some of these points Annie made in the introduction, but we believe that Ayers property is common where people have not had access to the legal system. You know, I think through a combination of both economic constraints and through discrimination. We know it's very common among African Americans in the Southern Black Belt. We believe, and some of my colleague Cassandra Johnson has done some research in Kentucky that shows it's common in the rural Appalachian region. We also believe it's common among Hispanics in the Texas colonias and perhaps more broadly in the Southwest. And it's also common among Native Americans, particularly where lands held in common were divided individual holdings under the Dawes Act and the other allotment acts. So my research focuses particularly on the Southern Black Belt. This area here, drawn on the little pamphlet by Wimberly and Morris. You know, one thing you see from that map is that most of the rural African American population is in the South, and I just wanted to sort of, as an aside, say that Ayers property is also a problem in urban areas. The Georgia Center for Ayers property is working in Atlanta as well, where it's a big problem. But for me, as a forester, I work primarily in rural areas, and when you work with rural African Americans, that almost for sure means you're working in the South. Just to give you a little bit of background on African American land ownership and also African Americans' relationship with our forestry, we know from a lot of research, I'm going to highlight particularly that by Robert Zabawa and Jess Gilbert, that there's been a precipitous decline in Black farmers in the 20th century. So there's just a small fraction of the ones left that were before. Now, part of that is due to an overall decline in small scale agriculture, but Jess Gilbert has pretty clearly shown that that the loss by African American small farmers exceeds that by white small farmers. We also know that in the 1990s, the USDA settled a class action lawsuit known as the Pigford case that they had discriminated among African Americans. They had discriminated towards African Americans in access to USDA programs, which are very important to being successful in farming. The other thing that happened historically was the Great Migration. We can say that probably took place largely between 1910 and 1970, which involved many African Americans leaving the South and moving to northern cities for industrial jobs. At the same time, we found in our research that even people that stayed in the South, that still have land, their families emphasize them getting an education and getting off-farm employment, often in education, but are engineers, doctors, or other kinds of professions. So there was this sort of move off the land. And one thing that happened also, probably beginning in the 70s and has continued to this day is talked about in Carol Stack's book called A Home, which is an issue, a situation of return migration where African Americans come back to the South, maybe to take care of their aging parents. Maybe they retire and they come back and they claim family land. Some of them go to the cities, but some of them go to rural areas. And for forestry programs that are working with African Americans in the South, these are often some of the first people that we come in contact with. In terms of forestry, as I said before, the legacy of African Americans was primarily in farming, not in forestry. When African Americans were involved in forestry, they tended to be involved in the very labor-intensive side of the work, in turpentining and pulpwooding, really the worst jobs in those kinds of professions, actually collecting the pine tar and actually doing the highly dangerous task of felling trees for shortwood pulpwooding. There was also a long-standing absence in forestry education, which led to an absence of African Americans working in the forest industry and a lack of role models in the African American community in the South. There's been efforts to address that over the years by educating African Americans, particularly at Tuskegee. The Forest Service founded a pre-forestry program at Tuskegee in 1968, and then in the mid-90s, Alabama A&M became the first historically Black college, the first 1890 land-grant university to get an accredited forestry program by the Society of American Foresters. But these facts all add up to a disconnect that remains there to this day between African Americans and forestry. The Sustainable Forestry and African American Land Retention Program was begun at the initiative of the U.S. Endowment for Forestry and Communities, which is based in Greenville, South Carolina. They got some of the money. There was a softwood dumping dispute where Canada was dumping below cost softwood into the U.S. That harmed forestry communities in the United States. And the U.S. Endowment for Forestry and Communities administers some of that money that was paid by Canada to the U.S. But it was established in collaboration with two USDA agencies, the Natural Resource Conservation Service and the Forest Service. This program began in 2012 with 3 pilot projects, which were in North Carolina, South Carolina, and Alabama. In 2015, additional projects were added in Georgia, Arkansas, Mississippi, and Virginia. This project brought together 2 goals, which were to help families retain land ownership and build assets through forest management, which basically meant addressing heirs property, and then promoting forest management and forest health, which was sort of part of the mission of the U.S. Endowment and the Forest Service, and also the Natural Resource Conservation Service. So this represents a sustained and integrated approach to forestry outreach and land ownership. It's been going on for over 6 years, but it actually works through community-based organizations. So each project, there are 8 projects in 7 states, there are 2 projects in Alabama, was implemented through a community-based nonprofit organization. So earlier, Mavis mentioned the Roanoke Rural Electric Cooperative, which has a nonprofit associated with them that manages a project in North Carolina. In South Carolina, it's the Center for Heirs Property Preservation out of Charleston, and there are different community-based groups that were selected because they were trusted and respected and had contacts within the organization. Each one of those groups put together a network that included state forestry agencies, FSA, which is the Farm Services Administration, which is usually housed in the same building as NRCS in each county, also representatives from the forest industry and from nonprofits. Each also had a mechanism to provide legal assistance for issues like heirs property, and they provided coordinated forestry and conservation assistance through networks. I think all these projects began with an emphasis on education and outreach to educate landowners. The action really comes after the education. And then these were done within this larger program that coordinated it. So we've done actually three sets of research, two of which I'm going to talk around here in coordination with this program. At the beginning, we did the baseline research where we talked to 60 landowners, 20 each in the sites of the three pilot projects. We started this about the time the projects began. And so, we tried to get within each state 20 people who were the most enthusiastic that had already become involved, and then 20 people that were not involved. It's, obviously hard to find people that aren't involved, with a purposive sample to represent diversity among them in terms of male, gender, actual landholding size, experience with forestry, all those kinds of things. Then we came in about 4 years later and did some more specific research about the factors that have led to success engaging African American landowners in forestry, which has been a continuing issue for many years. Just to go back to the baseline research, I don't know how much of this you can see and not being in the room and seeing what there, but most people were older, over 51. This is very typical for forest landowners in general. We had a good gender balance. We had a particularly well-educated group of people, which I think indicates that the people that became involved in the sustainable forestry and African American land retention program tended to be well educated. Many of them were teachers. Many of them were retired teachers, as you can see here, and they were not particularly wealthy because they'd worked in the education field. They tended to have acreage that was well suited for managing their forests. So you can see, over 90% had more than 20 acres. We didn't talk to people with less than 10 acres because that's not really enough to do forestry. But you can see that people had pretty large land holdings. About 40% of the people we talked to had heirs property. Most people had inherited their land. And I think one of the key things I like to point out, only 12% of the people were making a profit from their land. When we looked at their engagement with forestry, we found that they had not engaged in very many forestry activities outside of selling timber. They had tended not to use cost share programs until recently. These are the programs that the USDA offers to help landowners defray the costs of getting started in forestry and implementing other conservation activities. And they tended not to have forest management plans, so they were not engaged in forestry. To go back to the value of land, we talked to them extensively about their importance of land. And so one of the things I want to say is that many of these families obtained their land a long time ago, and it is passed on through multiple generations. And they obtained they obtained their land, their families obtained their land at a time when it was very difficult for African Americans to obtain land. This guy here, Joe Hamilton in South Carolina, his family attained their land when Sherman was coming through at the end of the Civil War. And the owner said, I'm out of here. Here to Joe's great-great-grandfather, here is some land that you can have. And Joe has gone from having that land in Ayers property to working with his family to earning Tree Farmer of the Year from the American Tree Farm System for his region of South Carolina. So that's just a tremendous success story, and he's a very engaged and active person. But the important thing is that African American owned land represented a shared resource and a home place. Now both Mavis and Annie sort of came down on slightly different sides here. People own land. Oops, I didn't mean to go do that. Let me go back. People own land both as a challenge and as a refuge from racism and oppression. It also provided an economic resource for farming and a place people could always stay. We have found in our research, and when we talk to people, attorneys, they don't really like to hear this so much, but we have found a number of people that tell us that their ancestors left their land in heirs property intentionally, not so much as Annie suggested, her colleague had said, to entangle it, but primarily to keep it as a resource that was owned in common by the family. Now, we're working on a paper with Thomas Mitchell, who was one of the key people behind the Uniform Heirs Property Protection Act. And when we tell them this, you know, from an anthropologist perspective, this is very interesting to us because this is what people have done informally. When we tell him this, you know, he says, well, that doesn't work. And we say, well, we know that doesn't work, but that doesn't mean that it didn't work for them for a number of years and that it reflects their interests. So, so sometimes people, this land was often intentionally tried to be maintained and managed as a family resource, and it continues to be important to those families. One, because of the memories that individual people that are still involved with the land have on that. The other is, there are old family houses, graveyards, cemeteries there, and African Americans were often not able to be buried in the main cemeteries in their town, so they're sort of absent from the landscape except for on their own family lands. And people also talk about wanting to honor the hard work and struggle that their ancestors did to obtain and to maintain having land. And many times their ancestors told them to keep the land in the family. At the same time, as I said before, only about 12% of people are making profit from their land. So land can be a burden. People have to pay taxes on that land, and it's not an asset. Heirs property presents a number of challenges. Families have to decide what is owned by a number of different people, how they're going to pay taxes, how they're going to use the land, and there are a variety of different stories about both conflict and agreement about how people are able to come together to deal with heirs property. It also presents limitations to their land. We found when people still had farmland, they tended to rent it to a family or a friend or someone in the African community that was trying to get started in farming, but received actually relatively low returns from that. There's very limited ways you can invest in the land because it's co-owned, and selling timber is not legal or is very difficult. Coming to some sort of resolution is also very complicated. As Mavis said, you can actually have hundreds of people that are scattered, from California to New York to South Carolina, and you have to find them. You have to agree on a path forward, and you have to have some legal help. When we talk about how does forestry relate to people with heirs property, we found and we actually in our baseline research had a forester go out to each one of those 60 landowners and do an assessment of their forestry, and they tended to have a very low quality, from an economic point of view, forests that had naturally regenerated either after abandonment of agriculture or after timber harvest. And these are also often low value stands on smaller tracts, which are particularly difficult to harvest. In some cases, there was sort of an informal management system. I think most foresters today don't consider this to be a management system, but there was this shortwood pulpwooding and shortwood harvesting system done with small trucks and with people out on the land with chainsaws. So some people did some uneven management of their land, but the current logging equipment and the current safety rules don't really allow people to do that anymore. So people often engaged in very opportunistic timber sales. Often someone would come up and offer them some money for their land. Sometimes it sounded like a lot of money, but they didn't really know what their timber was worth. I met in Alabama one time, there was a guy over there that was going around writing people $5,000 checks and saying, if you ever want to sell your land, just cash the check. And sometimes those people have $100,000 worth of timber on it. On their land, and so this lack of historic engagement with forestry meant they don't know the value of the timber, they don't know the volume, they don't know what's out there, they don't get multiple bids, they don't use a consulting forester who is trying to get a percentage of the returns and therefore has an incentive to sell the timber for as much as possible. They often, I can't get the signatures of other co-owners to sell timber, which means they tend to sell to unscrupulous loggers for low prices. Because they get very low returns, they tend not to plant trees or to manage their timber. And so you get this cycle of sort of low returns and underinvestment in forestry that leads with land being a cost, not being an asset. So what has happened under the Sustainable Forestry and African American Land Retention Program? One thing, by getting all these agencies and all these forestry folks and the attorneys working together, we found that one person can get a forest management plan for heirs property, even if they own it in common with other people. And they can even participate in some of the financial assistance programs like EQIP, which shouldn't have a U in it, it's just EQIP, which is an NRCS program that will pay you to get a forest management plan. So they can get that even as an individual. So they can get that plan, and as a part of getting that plan, they get an estimate of the value of their timber, so they can plan for and estimate some of the future returns that could be had from the land, and they can share that information with family members. And oftentimes, being able to show how that land can be productive, being show that the value is out there, does not lead to people arguing about who's going to get it, but actually gets them all able to come together and talk about what they want to do with the land. And essentially by increasing the size of the pie, it makes it easier for people to come together, because all of a sudden the land becomes worth much more than it was before. And it also shows people how, if they get involved in forestry, the land can build intergenerational wealth and knowledge about forestry, and it can also help them retain this land that's very important to them for their family heritage.
John, sorry to interrupt. I just want to, we're at time. If you could take 2 or 3 minutes.
Yeah, that's about what I have left. I'm sorry. I thought I was going to be over really quickly. But anyway, this program has been very successful. You can see the statistics up there at the top. I didn't put the statistics in for all these different outcomes, but the important thing, if you look down here under land tenure, you see we've divided up into all these different things that Mavis talked about, because it's, like if you made ultimately clearing the title to be the measure of success, you'd miss all these steps that lead up to it. The program is successful, I think, because it is this very integrated program. It integrates both the legal and the forestry part, and also integrates the forestry part in some different ways. And so to sort of end, I think one of the things I'm trying to say, one of the important points, is that heirs property exists not because people don't think the land is important, but because they operated outside of the mainstream legal and economic system because they were forced to. And but today it keeps people from benefiting from the land, not form. I thought I fixed that, and it gets worse over time as it gets passed on from generation to generation. It takes lots of time and effort to resolve, but it seems to work best here when you link the resolution to heirs property within something that's related to economic development, asset building, and empowerment, because that gives people a reason to want to resolve the heirs property. So we have 3 publications. I have here, we have 2 more in process. The one I mentioned before about trying to show the sentimental and cultural value of land to African Americans related to the Uniform Heirs Property Protection Act, and then the one about engagement with forestry. So that's all I have. I'm sorry I went a little over.
Totally fine. Thank you so much.
And
And with that, we will hear from Jesse Richardson.
Well, I was really delighted when Annie contacted me to be part of this Heirs property panel. Heirs property is a big part of my life. I have done a lot of research and work on it. When I was in private practice, for some bizarre reason, I got a whole bunch of heirs property cases. And so, in the one law review article that I published recently, all of the examples that I use but one are from my law practice. And they're very messy. I'm not going to dwell on this except to mention I'm glad that Annie talked about not only is this an economic issue for the landowners, for the heirs, but it also has a huge impact on communities. Heirs property is highly correlated with poverty, and I don't think that's an accident. Because they can't use this property, can't economically develop it, it drags down the communities as well as the owners. And I'm going to agree with the prior two speakers and make it unanimous that we disagree with Annie.
Not my points, but...
And we're not really disagreeing with Annie, we're disagreeing with the Center for Community Progress, who we've worked with, and they're great. That next point, I think the reason that we have heirs property is that it's what we call identity property. That people feel like the land is part of not only their personal identity, but their family identity. And that's a huge issue in West Virginia and in Appalachia. There are some people who inherit property and don't know that they have it. But in West Virginia in particular, we know that there are people who realize that they own the home place or part of the home place. And they would never think of selling it. They live in California or whatever, they're never coming back, but it's the home place. And it's part of their family, it's part of their heritage, they're never getting rid of it. But as Annie mentioned, a lot of the home places become dilapidated and abandoned because those owners never come back home to maintain it and take care of it. So there is a huge link between dilapidation, abandonment, and heirs property. And that's kind of what I'm going to focus on in my talk. Annie mentioned the economic concern and the vulnerability concern. And Mavis talked about how lawyers tend to focus on the economic concern, perhaps. And I would kind of agree that courts are going to sell the property because that's the easiest thing to do. They're not, in most cases, it's hard to divide it up, so they're going to sell it. But I think a lot of the nonprofits, a lot of groups out there, and the uniform partition of heirs property was mentioned. I'm going to mention that in a minute. It seems like there's a huge focus on the vulnerability concern. And the real concern seems to be that outside party purchasing a very small interest in the property and then filing a partition sale. And often at partition sales, the property sells for 10%, 20% of the value of the property. The heirs generally don't have the financial resources to bid on the property, and they can't borrow money against the property because they don't own the entire property. And so that seems to be the scenario that people are afraid of. There are assertions that that is a widespread practice. We have absolutely zero empirical evidence of that. And that's actually a project that I would like to do. I would love to get funding for the clinic. I want to give a shout out again to the Land Use Clinic. I have one alumnus and 2 present students here for the clinic. They're in the record room a lot, and I want to put them in there more. I want to send them out to the record rooms and find out how many of these heirs property does that outside party come in, buy an interest, and then file partition. It will be fascinating to find out how often that happens. But now I feel a little bit about like Lisa now, because everybody's concerned about the vulnerability of these tenants, and so am I. But now I'm going to kind of go rogue and say that the problem is we're not worrying enough about the economic concern. And just as Lisa is sometimes disparaged for that focus on white Appalachians, I'm sometimes called a heartless capitalist for focusing on the economic concern. I went to law school, so I guess I'm heartless, but I get it. I get the identity property, but this is another issue. It's kind of spinning out that economic concern and the fact that tenants can't borrow against the property because they need unanimous consent to do anything. They can't use the property. So this has been called the tragedy of the anti-commons. We've heard of the tragedy of the commons, but the tragedy of the anti-commons is the opposite, that we have many owners. All of those owners can limit access to the property. All of those owners have to consent to use of the property, so we get what some of you, I have some people from my property law class too, that's waste, underutilization of the property. Posner has said it's the same position as the inhabitants of a society that does not recognize property rights. It's also been called trapped capital because it's just there and nobody can use it. So some of the policy recommendations Mavis talked about, and we also heard later, we need to consolidate title, we need to clear title, management like LLCs or trusts or other things. The Uniform Partition of Heirs Property Act, which was enacted in 2006, it's been adopted by about a dozen states. It's been introduced in West Virginia, and I have to say my law review article is basically a critique of the Uniform Partition of Heirs Property Act. I don't like it because it really protects co-tenants against the vulnerability concern based on this third party coming in and buying it and filing partition, but it hurts people as far as the economic concern. So I think that's a problem. We also have some people talking about, let's make it easier for the co-tenant in possession to gain title through adverse possession. If one tenant is paying the taxes, let's allow forced sales to the tenant that's paying the taxes. As Mavis said, clinics could do wills. Legal aid could do wills. There's been a suggestion that we require wills if you're going to participate in government programs, and require that you have a will if you're going to participate in USDA or HUD grants, and to use some of that money to clear title. Eminent domain has also been suggested by me because it would clear title. And if any of you, I loved it because I was talking to former Dean McConnell when she was dean of the law school, and she was one of the few persons who actually gets this. I said, let's use eminent domain, and she said, when has eminent domain ever been used to help poor people? And all I had to say was midkiff. and nobody gets it. Sorry. Hawaii versus Midkiff, United States Supreme Court, look it up. Sandra Day O'Connor wrote the majority opinion. Hawaii decided that land ownership was too concentrated in the state, so they went in and condemned all of the property and distributed it to the tenants. That's similar to my proposal. Condemn heirs property, clear the title, give it back to one heir, so that we consolidate title, keep it in the property. Co-tenancy agreements, LLC, education that Mavis mentioned, hugely important. But what I want to talk about today is receivership. And Annie and I got excited about receivership about 2 years ago when we were working on this issue to put together our dilapidated buildings toolkit. And then we kind of cooled off on receivership because we said, well, it has to be income producing property or this isn't going to work. But then I discovered that there are some states and some local governments using receivership in some really unique ways. So receivership was initially to take over apartment complexes where the slumlord wasn't maintaining it. And so the local government would come over and take over. The second generation of receivership allowed tenant groups to do that. In my opinion, we now have the third generation of receivership, and that's for abandoned and dilapidated buildings, which is associated with heirs property. And so some of the advantages of receivership when it comes to heirs property, and I don't have enough time to really get into in rem versus in personam, but tax sales and other forms of trying to get abandoned properties fixed and maintained, we have to track down the person and we have to serve them with notice. With heirs property, we don't know who they are. And if we know who they are, they're out of state or we can't find them. Receivership focuses on the property, so all we have to know is where the property is. We don't have to find all of the people. Now, they get due process, but we don't have to have in personam jurisdiction. It clears title, it consolidates title, and if the heirs are in a position to assume the title to the property, we can address the vulnerability concern as well. So I looked at 2 states and the city of Baltimore, and this is great too because we get the communities involved. In Tennessee, any owner that's affected by the dilapidated property can file for a receivership. So that can be a neighbor, an interested party is a mortgagee or a lender or a judgment creditor. It has to be a public nuisance. Well, a lot of times public nuisance can be defined pretty broadly, and these abandoned properties reduce the value of the other properties in the neighborhood, so that in and of itself can be a nuisance. The owner has to come up with a development plan. If they do not, they can appoint a receiver, which is either a municipal corporation or a certified nonprofit, a nonprofit that knows what they're doing with abandoned and dilapidated buildings. This is important. The receiver's lien is super priority, so the receiver gets their money back before anybody else does, and if there's not enough money to pay that lien, the court can order foreclosure. So this is a way to force the properties to get put back into the economic stream. In Louisiana, it's blighted property, and this is a good stage to make another point. This statute was passed in response to Katrina. What we are finding in West Virginia, and when Katrina was a huge turning point, FEMA comes in, they want to give you money to rebuild your house. You got to show them you have title. So there were thousands of properties in New Orleans and in other areas where people said, we don't know who owns this house. So FEMA said, no money for you. So in West Virginia and other flood-prone areas, heirs property, we need to resolve it so that when these natural disasters hit. Similarly, they have a rehabilitation plan. The receiver must be a local government or qualified rehabilitation entity, and the lien, again, is super priority. Baltimore's is the best. I wish I could say that about baseball as well, but my Orioles are struggling. Maybe we can get a receivership statute that can help us get some starting pitching, I don't know. But it applies to any vacant structure. And here's why Baltimore's is so great from a heirs property and otherwise situation. In all of those other statutes, the receiver has to rehabilitate the property before they can sell it. Not in Baltimore. They can sell the property, and this is better than a tax sale. And Annie's going to have flashbacks and nightmares now because she did a lot of tax sale research for us. But in West Virginia and a lot of other states, people who bid at tax sales are speculators. If any of you are up at like 3 in the morning watching TV, there's actually commercials where make millions of dollars buying tax liens. And they even have conferences and stuff. I want to go to one and just to learn about it. But they buy these tax liens sight unseen because the state of West Virginia is paying 12% interest on it. And so they just sit there and hope that they get the interest. And they have no interest in rehabbing the property. Baltimore, you have to be a qualified buyer. You have to have a plan that you're going to rehabilitate the building. Again, they get a super priority lien. And I have a long conclusion here because Annie highlighted this, that she really liked this. But basically, receiverships are only going to really happen if it's heirs property. Because if the property can be economically redeveloped, the owner's going to do it. If we can't find the owners, if it's this mess with title, then the receiver can step in and take care of it. Now, why am I also excited about receivership fitting more broadly into the theme of our session here today? Is because today we have some local governments saying, let's address dilapidated buildings with receivers. What I can see in the future is if you have an economic use of the property, let's say forestry, let's say agriculture, let's say coal. We should have put coal in the title of our session. Then it would have been full in here. But in a state like West Virginia where oil and gas can be taken from the property, and to get back to Mavis's statement that we need creative solutions, what I've also written about and what I think is neglected is that yes, we have identity owners of property. We have people where that property is literally their heart and soul, and they don't want to get rid of it. But we also have what I have classified as trapped owners. Owners that they don't really care about the property, and they're poor, and they want to get their money out of the property, and they can't. And we also have what I call opportunistic owners. Every case that I've had, and I'd be interested if Mavis shares this experience, at least one of the heirs has been crazy. And one of the heirs, think of your own family, right? Yeah, there's at least one crazy person, right? But there's usually one heir that lives in the home place. They don't pay the taxes, they don't pay the rent, they don't even repair the place. sometimes one of the other heirs has to pay the oil and gas to heat the place and pay the electric bill. And so when we say, hey, we need to do something about this, that heir always says, well, yeah, we can settle this. There's 3 of us, there's 100 acres. I'll take the 50 acres that has road access and is flat. You all divide the 50 acres that's steep and has no road access. That's fair. So I think using receivership, we could do something, for example, let's sell the oil and gas. Those identity owners that want to stay, they can use that oil and gas money to buy out the other owners, and they can keep the property, and we can have our cake and eat it too. So I'd like to close on that optimistic note of hope, Annie.
Great. Well, thank you so much to all of our panelists for this really interesting discussion. I think each of these talks complemented the others really well. I think we've fully vetted my theories that I threw out there from the beginning. We don't need to revisit those. But I do have a couple of questions that I'd like to pose to the panel as a whole. So I'm going to put a little bit of pressure on each panelist, and we've covered so much territory today. If you had to pick one solution, clearly there's no silver bullet solution to these thorny issues, but if you could pick one solution as your favorite or as the most important solution for heirs property, what would you pitch as that? And so let's go in the order that we heard from everybody. Mavis, could you start us off? Sorry, Mavis, did you hear me?
Yeah.
Okay.
Yeah, I heard the question.
Great.
Can you hear me okay?
Yes, thank you.
Yeah, if I could pick one solution, and I thought about this while Jesse was talking about receivership. I think that's pretty brilliant. But I would say that I think our legal system is too rigid and isn't innovative. And I think that policymakers, legislators should take innovative approaches to problems like this, problems like the complexity of heirs property. Take innovative approaches like they do with technology. You know, technology is so innovative in 2018, in the 21st century, and our laws, particularly around land, are not. And so that doesn't really answer your question directly, but I think that we could reform our laws around land ownership so that they suit the current needs, because they don't currently suit the needs of landowners.
Great, thank you. John? Uh-oh, he disappeared. John, can you hear me? We lost John. All right, okay, we'll try to come back to John. Let's go to Jesse then.
Obviously, I like receivership. I recognize. Oh, okay.
John, you're there?
Yeah.
Okay, we'll come back to you, Jesse.
I'm sorry, I had muted myself in 2 different places.
Okay.
Yeah, well, I think what I want to say is that, which is kind of the opposite of saying there's one solution, is that I think that the solution really needs to be embedded in a comprehensive justice and economic development plan. That I don't think you can address it just on its own. And I'll just leave it there.
And I'll just add that I recognize that receivership's not going to solve every problem. So I'll cheat and have 2, and I think Mavis mentioned education, and that I think is kind of the starting point for just about every problem, is educating. And I don't mean just owners of heirs property, I mean judges, lawyers, everybody involved in the process.
Great, thank you. Great, well, I certainly have more questions up my...
And can I cut you off?
Sir, what was that?
I just want to can I cut you off?
Yes,
I
please, go ahead.
Add on to my answer, piggybacking off of,
Yes.
Can you hear me?
Yes.
Piggybacking off Jesse's answer, I think, I'm biased here because this is what I do in my law practice, but I think working on heirs property is a great opportunity for law students and young lawyers to gain really practical skills in the legal field, because it mixes real estate, it mixes tax, it mixes business law, it mixes estates, trusts, and so another solution I would add on to that is for law schools through their clinic programs to offer services that are, again, robust and designed to be innovative in addressing those needs. So I would add that on to there.
I'm with you, Mavis, and I'm working on it. If I can get some funding for the land use clinic, that's what we'll do.
Great. Great. Well, I was hinting at, I have plenty of more questions that I'd be happy to run with, but I wanted to open it up to the whole room. I think we have quite a few law students in the room. Does anybody have anything they'd like to throw out there to the panel or any of our individual speakers?
I want to thank you all for hanging in past the time, but we have a question.
Great. Yeah, we have one hand.
Yeah, I was just thinking if you're going to try and ultimately get the property to one of the heirs, I mean, what problem? I came in just about 15 minutes late, but how do you determine which one is kind of worthy of making those decisions or ultimately receiving it in the end? And that seems like it's its own battle, let alone how to use the property.
And that's a really tough question, but sometimes, usually, maybe, there's only one person that's actually living on the property, and in that case, it's kind of a natural fit. But that's a great question for me to kind of segue into something related to what had been said earlier. I advise a lot of farm clients, and I always tell them, if they want the farm to stay a farm, pick one child. Nobody has ever listened to me. So there's a lot of evidence in Virginia, West Virginia, that what once started as maybe 1,000-acre farm, and it was economically viable, left to the children equally, left to the children equally, left to the children equally. Today, a lot of those farms are now 50 acres, and they are not economically viable. So if you want a farm, you need to pick one, and that's regardless of whether you are, it's heirs property or not. So some have suggested a return to primogeniture. I'm not sure if that's appropriate, but that did solve the problem.
John and Mavis, did you hear the question?
No.
Sorry, John, I want to make sure I get it right. Can you repeat the question loudly?
Yeah, so my question was just as far as receivership and just that theory, how do you determine out of the several heirs that could own the property, who gets to receive the property and how it follows from that point?
So if you have to pick an heir, how do you pick the heir? Either of you want to speak to that point?
No, I haven't worked with the receivership, so.
Okay.
I would say that's one of the things that occurred to me as well, as it was being discussed. Because I think even the example that Jesse gave, that the person that's actually living on the land might not be the person paying the taxes, or paying the utilities. So you already have two people with a claim there. I do think there needs to be it would be good if there were a streamlined way to do it. There are people that have very small interests that don't really care about the property. But how you do that fairly, I think, would be a real challenge.
Jesse, again, I'm not that familiar with receiverships, but can you have a family-owned LLC that's appointed as a receiver, or does it have to be a human?
Well, at this point, it has to be either a municipality, a human, or a qualified nonprofit. But going back to your earlier points about needing to be more flexible and more creative, I think in the future the receiver could be the vehicle where you would create that LLC or use that LLC to manage the property. So I think that's definitely a possibility.
Great. Any other questions from the room? I have one last one I want to pose to the panel to close us out. If you could make one point about changing the narrative on Ayers property, what is the one point you would make? And we'll start with Jesse, then work our way backwards back through John and Mavis.
Okay, well, I'm going to steal Mavis's thunder and say that this duality that we have now, that you either sell it or you keep it all, I think we need to realize that there's a lot of solutions in the middle. We could sell part of it to pay off some of the heirs. We could sell the oil and gas. There's just a lot of creative solutions.
Thank you. John?
I think I want to say that people have heirs property, and it's important to them because they operate outside the legal and economic system. And you know, and that's why it's important to them as family land, because they're not represented out there in the rest of the landscape. I've been reading this book called Trace, which is a very interesting book to read about that. And so, you know, I guess that's partly why I argue that it's not just a legal system, because it exists and it's important because people are outside the legal system. And that's why I'm suggesting it should be embedded in a larger economic justice program.
Mavis?
Yeah, I view land as opportunity. I know we focused it around families and intergenerational wealth, but you know, just bigger picture, land matters to all of us, and the viability and the resiliency of land ownership has significant impacts also from an environmental standpoint. You know, I'm on the board of directors for a land conservation group, and a lot of the families that we have conservation easements with own the land as heirs property. So it matters to all of us, and there's great reasons. You know, we all need water, we all need clean air, we all need food. So land touches on many aspects of all of our lives, and I think that we need to think about it in that way rather than just thinking about the unique structure of ownership of heirs property and how to address those issues.
Great. With that, I'd like to thank the panelists, especially those working with the technology to come in remotely. Thank you to our audience for sticking around through the end of the symposium. So a round of applause for everybody here.